Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. We'll start the case on behalf of the prosecution. May it please Your Honor, I am appearing on behalf of the state. I am the public prosecutor. The brief facts of the case are like this. You have to reiterate the facts which I told in the last video. Now, as far as the prosecution is concerned, Your Honor, there is a clinching, categorical and ample evidence to fix the accused to the crime, to prove the case beyond all reasonable doubt. Your Honor, the accused, please remember, accused was last seen in the company of the deceased. The last seen theory, even in 300 cases also, section 300 cases also, last seen theory is the most important one. For this connection, the PWs 3, 4, 5 stated that while they were going to the fields, they have seen the deceased giving lift to the accused person. But later, only the accused was found by PW5 but not the deceased. So, last seen theory. It is clearly proved that the deceased was seen in the company of the accused. So, please, in this case, I want to submit that in the famous case of Keshav versus State of Tamil Nadu 2008, the circumstances of last seen theory becomes relevant only when death is proved to have taken place within a short time. Yes, it happened like this, Your Honor. So, within a short time between Kareju and Singarayakonda, this incident happened. And I suppose to support this, there is another case, Your Honor. This is Mamind and others. Mamind and others versus State of Tamil Nadu 2008. Yes, Your Honor. So the last seen theory is clearly getting proved. And the second point is the extrajudicial confession. No doubt, Your Honor, extrajudicial confession can be taken as a confession since it is not made before the police. It is done before a third person. Definitely, extrajudicial confession made by the accused before the third person is found to be relevant when it is reliable. Definitely, it is reliable because of the consolation to the others, because of the connection or corroboration to the other circumstances. Because, Your Honor, in this case, after the accused gave the confession, then the police took him in custody. When Maheshwara handed him over, then they went to Ulapadu, recovered the clothes which were kept in a dig. Actually, he has thrown them in a pit, kept in a pit. And later, the police proceeded to Kavali. They recovered the gold ring which he has sold for 10,000s. And also, they have actually taken the relevant documents of the hotel in which he stayed. So, according to Section 27 of the Indian Evidence Act, the confession leading to the discovery of the facts is 100% relevant, Your Honor. Nothing more than that is required. So, please remember, in this case, I want to submit the case law, that is Kusuma Ankamarao versus State of AP 2008. It supports the so-called extrajudicial confession. More than that, there are witnesses. No doubt, they are witness, Your Honor. Other side is saying that they are interested in the cross-examination. It's not correct. There are the witnesses. The witnesses' evidence is ocular. It is up to the point. And no doubt, some of them are related, Your Honor. There is no point in discarding the evidence because they are the interested witness. In the famous case of Daulatram Sukhram Telli versus State of Chhattisgarh, 2008, Your Honor. So, alleged interested witnesses, definitely, since they are family members, it cannot be, their evidence cannot be discarded. Yes. And coupled with this, please remember, no doubt, the offence took place on 23/3/2019 and reported on 26/3/2019. Till such time, witnesses, the relatives, the Venkateshwarlu, Ramanjaneyulu and father of they were making frantic searches for him. So when they came to know the presence of the dead body, they saw the dead body, they identified it, and immediately they went to the Singarayakonda police station and they reported the matter. There is no delay in reporting the matter, Your Honor. Immediately it was. So it is the duty of the police. Your Honor, very celebrated case law, Lalit Kumari versus Government of UP 2014. So as per this, the police registered the case, they took up investigation, and actually they have recovered the clothes present. So material objects which are necessary, which say the presence of the accused. How? Your Honor, I tell you that the material objects which were seized, like beds in earth, control earth, and other materials seized from the scene of offense, they were sent to the forensic laboratory. So it is clearly established that the blood stains on the items were that of the deceased person. And later, the clothes of the accused, which were actually thrown into the pit near Valamapadu, they were also sent for the forensic examination, and the police got a positive reply. So to corroborate all these things, the forensic science evidence is 100% leading towards the focusing toward pointing toward the accused. Moreover, Your Honor, the medical evidence according to section 42, the medical officer is also an expert. Medical offense, it is medical evidence. The post-mortem certificate, it is stating clearly that the accused died of head injuries. How the head injuries are called? The accused voluntarily confessed that he bit or he hit the deceased thrice with a big boulder, and that was also seized, Your Honor. It was also having blood stains. So the circumstances, they are all pointing to the crime towards the accused. So the circumstances, definitely all these things put together, the medical evidence, the forensic evidence, and the evidence of the witnesses, they go to say that yes, this man has committed the dastardly murder. And as regards, even though people say that there is a delay, if the delay is properly explained, the delay means incident took place on 23 and report was given on 26th. So if the delay is properly explained, then definitely you cannot take the defense of undue delay in rejection FIR. This was stated in the famous case of Chandrappa and others versus State of Karnataka 2008, Your Honor. Moreover, Your Honor, the accused, you may be knowing already, he is undergoing trial in crime number. So in a case, in another murder case, he is taken trial in another murder case, Your Honor. It shows according to section 52 of the Individuals Act, the previous conduct is also relevant. So therefore, there is one famous case, Your Honor, previous conduct can be taken into account. Of course, in not civil cases they don't take, but in criminal cases, in Tara Devi versus Union of India 1991, and also Sardar Shardul Singh Kaveshwar and others versus State of Punjab 1963. It is otherwise called as Empire Conspiracy case. Yes, in this case also it is clearly held that, so if the previous conduct is if he is involved in a previous case, the court can draw the inference, Your Honor, even the demeanor of the witness can be taken into account by the court. So the previous conduct, previous involvement, if the accused is let free, definitely there is likelihood of committing another murder. So therefore, coupled with all these evidences, that is the number one, last scene theory, second, extrajudicial confession, third, 100% true recovery by the police and the exhibition of the material objects, and they corroborated with the medical evidence with the post-mortem report. All these things go to say that this accused committed the offense of 302. Moreover, as far as 404 is concerned, Your Honor, normally the dead body should be respected, but he doesn't have that much of sense also. He has plucked away the gold ring from the dead body and he has sold it at Kavali. It was also recovered. Therefore, he is liable for both 302 and 404 IPC, Your Honor. So, no leniency should be shown toward the accused, since the evidence against him is foolproof, ample, cogent, convenient, and the prosecution is able to prove the case beyond all reasonable doubt. Therefore, the accused should be convicted with the maximum punishment. Your Honor, this is a classic case where a person who has given a lift he has been done to death by the accused person. Such people should not be allowed to move in the society. Therefore, he should be convicted. With this, I am concluding my arguments, Your Honor. So like this, you have to say. Already 10 minutes over. Thank you very much.